Thanks, everyone, for calling into today's webinar on the on-demand economy. This is Sam Munger from SiX Action, and we are hosting this jointly with our good friends at the National Employment Law Project, or NELP, whom we work with on a number of issues, but on this one in particular. We are going to get going because we have a fantastic panel, which you will be hearing about in 1 minute. But before we do, I just wanted to let you know that, first of all, you are all, as participants, you are all on mute at the moment. We have enough callers, too many callers to have folks be responsible for muting themselves individually. So we keep everyone on mute except for the speakers. However, there are a number of ways to make your voice heard. You can submit questions either through the chat function in your webinar software, which if you aren't familiar with, it's in sort of the upper right corner. There's a little panel, and you just type in a question, and we will take them in the order received, but we'll take them at the end after each of our panelists have an opportunity to speak, but we will leave plenty of time, don't worry. And we will, as I said, we will be getting to them. At the end, we'll have time for Q&A, and we'll read off the questions and then have our panelists answer them. And feel free to direct them to a particular panelist. We will also be following up after this webinar with an email to everyone. It will have links to all of the materials that you'll see. It will have contact info for all of the speakers. So if you are looking for materials from this webinar or additional materials on the topics covered, if you're looking to get in touch with folks on here who I'm sure would be happy to help you with additional questions on this, that will be coming around, don't worry, and we will be sending that around to anyone who is registered for the webinar. So without further ado, let me turn it over to my colleague Kim at the National Employment Law Project to introduce the topic and the panel for today's discussion.
Thanks, Sam. Hey, everyone. I'm Kim Deal, and I'm the Communication Strategist here at National Employment Law Project. I'm really excited to be here and be your moderator today. I also wanted to let you know that we're going to be having a poll, 2 poll questions during this webinar just to keep you on your toes, and we want to learn more about you. So please expect poll questions, and Sam or Vanessa will introduce that poll and before we do it. But basically, we just want to know a little more about you all and what you hope to learn from this. So I'm excited to present to you 3 folks who are going to basically walk us through how the on-demand economy fits into the overall economy and workers' rights, examples of policies that exempt on-demand businesses from typical employer obligations, and then how we can best provide security for gig economy workers. Our first panelist is going to be Dr. David Whale, and then we're going to be hearing from Rebecca Smith from National Employment Law Project, and then we'll hear from Larry Engelstein from SEIU 32BJ. So first we're going to ask you a polling question. Sam, would you like to start?
Sure. I had not. So we're going to start with poll. This will appear on your panel on the right as a series of options. At least it should. And the question is just getting a little bit of background on our audience. And that is, the question is, what sectors you guys hail from? So in other words, I'm going to read off a variety of set of terms, and you tell us which of them best describes your work. So are you a legislator? Do you otherwise work in government, in a non-elected position? Are you from a union, from a worker center, a lawyer, a labor lawyer or other, a labor or other kind of lawyer, or something else? And there should be 5 options, 5 little radio buttons that appear on the right. There you go. And you should be able to click on these. So just take a minute and answer that.
Thank you, Sam.
It takes the software a couple minutes to tally it. I mean, it'll take a minute for everyone to register their selections. I don't know if this is of general interest, but there will be some other polling questions that probably are, and we can relay the results of those later on if folks are interested, but it just will take us a few minutes. So in the meantime, take a minute to answer that question, and we will then move on with the briefing.
Wonderful. So I'm going to introduce next our first panelist, Dr. David Weil, and he is the Peter and Deborah Wexler Professor of Management at Boston University's Questrom School of Business, And we know him very well as the appointee of President Barack Obama, to the administrator of the Wage and Hour Division of the U.S. Department of Labor. And he led that division from 2014 to January 2017. Under his tenure, the DOL made tremendous strides under his leadership to combat wage theft and to otherwise defend workers' wage and hour protections, including those in the gig economy. He's internationally recognized expert in employment and labor market policy, regulation, transparency policy, and digital empowerment, as well as the impacts of supply chain and industry restructuring on employment and work outcomes. He's also an expert in public and labor market policy, industrial labor relations, and more, and we're excited to have him as the author of several books, including The Fissured Workplace, How Work Became So Bad for So Many, and What Can Be Done to Improve It. So, David, can you take it away?
I can. Can you all hear me?
Yes, we can.
Hello? You can? Oh, terrific. Well, I'm delighted to be with you all today and to talk about the issues of the on-demand economy. And I do want to link it to the broader issues that Kim just mentioned of the fissured workplace. And if we could go to the next slide. I have been in many discussions over the last few years on the future of work. And in many of those discussions, people often speak about the future of work as if it is entirely about the on-demand economy. And while I know there are important issues we need to discuss specific to the on-demand economy, it is also really important to understand that much of the future of work, as is true today, is in this larger fissured workplace, which is occurring in all sectors of the economy and is affecting all kinds of work in our economy, both in the on-demand sector, but more generally in some of the oldest parts of our economy, in manufacturing as well as in service, retail, virtually every part of the United States economy and around the world are being affected by this. So let me talk briefly about what I mean about the fissured workplace, and then I want to connect that idea to some of the issues that we'll be discussing today. When I talk about the fissured workplace, I'm referring to a whole set of changes, many of which everyone on this call is well aware of, things like outsourcing, offshoring, subcontracting, the increasing use of third-party management, independent contracting, are all aspects of what I've called the fissured workplace. But they are all really united by a common kind of driver, a common kind of change in the fundamentals of how businesses are organizing today and in the future that I want to talk briefly about. And I'll talk about it in terms of an example we all have familiarity with, and that's a hotel. Typically when we walk into a hotel, whether it's a Hilton or a Marriott or a Holiday Inn, we associate everything we see with that brand. We think that, and we do so for good reason, because one of the key things businesses try to do is make sure you think of a Hilton as a distinctive kind of experience. And so everyone you see, all the services you receive, the kind of room you're going to have, the kind of everything from housekeeping to food availability is really dictated by that brand. But if you actually look below the surface, and if we could advance the slide, beneath that brand, in fact, now is a variety of different players, all of which have a role that, while the brand is still controlled by the major company, the activities in that hotel have been farmed out. And so typically in a hotel, ownership rests with a real estate investment trust or with private equity. Those folks hire third-party management companies in the hospitality industry to run the hotel, who in turn increasingly hire a whole series of different staffing agencies and other companies to provide different services, including things like janitorial, housekeeping, and other activities in that. And so while one might perceive, and while we often think as if there's one employer in that model, in fact, there can be 12, 15, 18 different employers involved in the employment relationship in a typical hotel. And that really is emblematic of what's gone on across the economy, far beyond hotels. And it's that marrying of strong control by a lead company with the shifting of activities and use of a variety of methods like subcontracting, franchising, and so on, that has been the growing part of our economy that I think also depicts where our economy will continue to move, and it's this fissured kind of workplace relationship. In the next slide, I won't go into detail, but there's been a recent study by Alan Kruger and Larry Katz, two prominent labor economists, that have estimated the growth of these kinds of work arrangements that are really the building blocks of fissured workplaces. And what they find overall is that between 2005 and 2015, somewhere between 80 to 100% of net employment growth, the net growth in employment over that decade period, occurred in these kinds of alternative work arrangements, occurred in these kinds of practices associated with the fissured workplace. And so when we think about the current state of affairs and the future of work, we really need to nest it in this larger restructuring that certainly many of you on this call have been working to deal with in a variety of ways, and certainly was our focus in the Obama administration's Labor Department to come to grips with that. Now, with that said, let me make a few comments specific to the on-demand economy to set up the remainder of our discussion. In the next slide, I show sort of the current, again, best estimates out there of the size of the on-demand economy. And if you look at sort of the number of people employed in some way in this economy, right now it is a very small part of our overall workforce. The estimate is less than 1% of our workforce. Maybe 600,000 to 800,000 workers are employed in this kind of work. There's no doubt that's growing. There's a lot of evidence. I think we're going to see evidence late in the next presentation of that growth. We have to, again, remember it's a small part of the economy. But having said that, let's think a little bit about how one thinks about the kind of work in that part of the economy. Really, it is another form, I would argue, in many cases, of fissuring, but fissuring through a digital kind of platform enabler or management system. And I want to, at the risk of simplifying the world a little bit, I'm going back to being an academic now after leaving the government, so that's what we do in academics. We try to simplify the world. Let me suggest there were two kinds of models in the on-demand economy in terms of what's happening with employment. In the next slide, let me depict the first kind of digital platform. It's what I would call virtual market providers. And in a virtual market kind of structure, what you have is, on one hand, and you see on the left side of the slide, a set of tasks. Let's think about maybe a company that connects people, consumers who want some help with problems in their home, with a set of providers of that. And a digital platform in these kind of virtual market provider situations do just that. They provide very real-time, sometimes very nuanced information about a bunch of providers of those services. And what I have on the right side are a set of different providers who might be able to come to your home and fix those problems on the left side. And in the middle, you have the platform itself, and the platform might offer these different people services at different costs because as independent players, those people are doing things like setting prices for their services, telling you about what they distinctively bring to those services, provide you information about other consumers' experience with those providers, and so on. And in those kinds of setups, you do indeed have a digital platform that is providing the kind of function that in the old world that I grew up in, the Yellow Pages might have, but in a much more virtual, data-informed and nuanced way. But the folks on the right side of the screen are doing work as individual, what we would consider traditional independent contractors doing that activity. And in terms of employment relationships, while those folks might face a lot of instability in their employment, a lot of variability in terms of their own ability to make paychecks and support their business, they are classic independent contractors enabled through a virtual market provider. Now, I want to contrast that with the second kind of platform that's out there that I'm depicting in the next picture. And in the next slide, we have what I would call, in contrast to virtual market providers, digital platforms that are providing a branded experience. So you'll see in the next slide, if we could cue that up, we're going to start with a set of the same tasks to be done. The same consumers want something done. And on the right side, we have a set of people who are able to do those services, but with a key difference. And if you look at the digital platform in this case, the digital platform is providing you a branded service. It's saying, come to us, we will provide you those home repair services at a given price with a certain brand identity. In other words, you're coming to the platform not just to get the services, but you want the folks who are wearing the same kind of red shirt, red emblems on the right side to do that work on the left side. In other words, what you have enabled by a digital device is a business strategy still built around a branded experience, just as you would go, a very different thing to go to a company that's provided a branded type of service to you, as opposed to going to your Yellow Pages and trying to figure out who might be the best person to provide you the service. And in this context, the stronger that middle digital platform is in dictating the price paid, the quality of service, the nature of service, the scheduling of service, the qualifications of all the people who are going to come to your home and any certification they might have, the closer and closer we get to a traditional branded business, which means the people on the right side of the screen are, in fact, probably employees of that branded experience platform. And it's that difference. If you think about the implications of that, it says a lot of the ways we need to think about the digital environment, the on-demand environment, in many ways might not be that different than we would think in a traditional brick-and-mortar situation. We would look at all the characteristics in employment law we would look at in any context to say, are the people who are actually providing the service doing so as independent contractors or as employees of that business or service? And so to wrap this up, in the end, what I would argue is, in the next slide, what we're talking about in the on-demand space in many, many instances is not that different from the kind of factors all of us at the federal level, at the state and the local level have struggled with in terms of the issue of misclassification of workers. Are you or are you not an employee, or are you a legitimate independent contractor? And while there are certainly on-demand players who live in a kind of a gray space between the two, that is also not unique to the on-demand world. We face that all the time in the old brick-and-mortar world as well. And we have to think about the same kind of factors in the two settings that we would. And so, as sort of stepping back and summarizing, if we think about the overall set of issues and framing whether it's public policy response, worker advocacy responses, enforcement responses, litigation responses, I would argue we need to cast it in this larger light that looks at fundamental principles of what a business is doing, what it's trying to do, and in the course of that, determining what's the nature of employment that arises from that. I think we don't need to start developing new forms of third ways in the employment relationship. Instead, we need to just go back and do the hard work of assessing what's the nature of the business and what does that mean in terms of the relationship with the workers who provide and create that value and provide that work. I think that will serve, first and foremost, working people best in this kind of space, but I think it will also allow that space to continue to develop and emerge and do a lot of the interesting things that are going on in the on-demand world at the same time as not undermining either the protection of workers who live in the on-demand world or that would spill over and affect the protections afforded to workers in the larger fissured economy. So let me close out with that, and I look forward to the discussion later on in our phone call.
Thank you, Dr. Weil. I do too. I had a lot of questions coming up, and I actually submitted one. So I want to make sure folks use the chat function and ask their questions so that it's not just me, but I really got a lot out of that presentation. Thank you so much. I wanted to also let folks know that we have a second polling question for you all, and we're going to take this minute before we hear from Rebecca Smith to ask a question. And are we ready for our second poll? Great. So we want to hear from you. What else would you like to learn about this concept of the fissured workplace that Dr. Weil was just referring to, or the on-demand economy? I'd like for you to answer that. So your selections are state and federal policy solutions, portable benefits, which we're going to hear about next and with Larry Engelstein's presentation, litigation, agency action, worker organizing strategies. I'm going to let you all take a second to do that poll. We'll give you the results of what you all answered towards the end of this presentation, just to give you a little suspense. So thank you so much. Next we're going to have Rebecca Smith. She's the Deputy Director at National Employment Law Project. She has nearly 20 years experience advocating for migrant farm workers in Washington State. And as NELP's Deputy Director, she works with unions, worker centers, community groups, and advocates to modernize state unemployment insurance programs, protect immigrant workers, advance the rights of on-demand economy workers, as well as others impacted by workplace fissuring. She is the author of several key publications on these and other topics, including the Rights on Demand series, which I believe many of you probably read and learned about this webinar. So why don't you go ahead and take it away and give us some the next step that Dr. Weil had basically referred to as far as what kind of responses we need.
Very good. Can everyone hear me?
I
yes.
can.
Yeah.
Yes, very good.
Okay.
Thanks, Kim, and thanks, David, as well. I just wanted to add one slide to David's slide. As we talk about the on-demand economy, it is a very small part of a much bigger problem of contingent and insecure work. And I think one of the reasons that it gets sort of outsized attention, in my view, is this very rapid growth in the last 3 years, a tenfold growth in the percentage of people participating in online work, and then a 47 or so increase in the percentage of folks who have ever participated in the online economy. And I think there's a lot of debate over whether on-demand is going to increase, whether it will go by the wayside. But I think knowing it in context and also the growth helps us think about how if we get it right for on-demand workers, we can also get it right for other workers. And if we get it right for other workers, we can also get it right for on-demand workers. So next slide, please. I want to just talk a little bit. In most of the on-demand jobs, some of the major companies operate with workers who they label independent contractors. And of course that means that there are no benefits like workers' comp. They don't pay into Social Security. If you're injured on your the job, you're on your own. If you want to join a union, you don't have the protection of the NLRA, and on and on. But there are many businesses in this space that also treat workers as employees and also provide them with extra training and extra benefits. And those businesses say that doing that helps them, helps the bottom line, and it also helps them retain good employees. As I think most of you know, there's litigation pending against many of the companies in the on-demand economy who do treat workers as independent contractors. And we would say, along with David, that when you just apply current law and the broad definition of employee in current law, you would come to the conclusion that, especially in those branded services that David talked about, that these workers are employees and are entitled to basic rights as employees. Nonetheless, we have seen a surge in legislation that proposes to treat workers in the on-demand economy as independent contractors, and then that of course means no labor rights essentially. And that's been especially the case in the area of transportation network companies. In 23 states, transportation network companies have been able to exclude themselves either in whole or in part from being employers under state law, so that they are not contributing to workers' compensation or unemployment insurance or otherwise making sure that workers get minimum wage, for example. Next slide, please. These carve-outs come as state agencies are applying existing laws and finding that these businesses are employers in the traditional sense. We think those carve-outs are wrong and that the law ought to apply to all kinds of employers. Some examples, with the Fight for 15 sweeping the nation, we think we ought to be applying minimum wage to these workers who are by and large in low-wage jobs. Many of those jobs are dangerous, and so workers could benefit from ensuring that they can have access to workers' compensation if they're injured on the job. And income volatility is really a hallmark of these jobs as well. There have been studies showing that workers who are in on-demand often have other jobs as well, but their income is going up and down enormously from month to month. And you can see here that states have taken a variety of approaches, including in Oregon issuing state guidance that Uber workers are employees. There have been audits, as in Washington State, of the company Postmates recently. And then there have been individual unemployment cases, and I believe workers' comp as well, where workers are contesting the agency's classification of the workers as independent contractors. There's a lot that agencies can do to ensure that these workers' labor rights are respected. Next slide, please. And we've thought a lot about what should happen at the state legislative level as well. So first, state agencies can enforce existing laws. But secondly, state legislators can clarify current law. Our proposal isn't really an expansion of the definition of employee, but we think it perhaps makes existing law a little bit clearer to stop some of the gaming that we perceive that is going on. What we're saying, and I think this is in line with what David was saying as well, is that these are workers who are doing the job of the company, and that's a traditional hallmark of employee status. They're home care workers working for a home care company. And even beyond on-demand, there are janitors working for janitorial companies who ought to be those workers' employees. They're not running a business of their own. And we think another hallmark is that if workers can't set the price of their own labor, they really can't be in business for themselves. I mean, think the difference of some of the branded companies that David alluded to, and the plumber who can tell you what he or she is going to charge to come to your house and fix your drains. So that's the first option, and we think that corrects not only for on-demand workers but for other workers who are traditionally misclassified. The second is really to think of sector-specific approaches. So just as some of the transportation network companies have exempted them, those companies can be deemed under state law to be employers and therefore contribute to workers' compensation, unemployment, pay minimum wage. And that concept comes from the Social Security Act, which also treats certain employers as statutory employers. So it doesn't matter what you want to call workers, you're an employer for purposes of these laws. Next slide, please. There's been a lot of discussion around the concept of portable benefits, and it's really an interesting discussion. Workers in many jobs, fissured or not fissured, need benefits that can go with them from job to job. And we think there's really a couple of steps involved in thinking about and creating portable benefits. First, there's an issue of inclusion, and we think that on-demand workers and others who are in the fissured workplace ought to be included into the benefits that I mentioned earlier: Social Security, unemployment insurance, and workers' compensation. These are workers who need these benefits, and these are benefits that are inherently portable, and contributing to social insurance allows workers who are in and out of on-demand jobs, or who hold an on-demand job at the same time that they hold a more traditional job, to take advantage of the same system that everyone else takes advantage of. We think that there is a place for portable benefits as well, apart from social insurance, but as a supplement to social insurance. And so we thought a little bit about some principles about portable benefits. Inclusion into the broader social benefit system is one. Adequacy is a second one. And that means both supplementing, not supplanting, existing benefits, which is why it's necessary to incorporate into existing portable benefits, and then enough money contributed by the company to discourage misclassification of workers as independent contractors. We think it's important that there be a role of workers' organizations. Workers' organizations can democratically represent their members, and they can help decide, or help workers decide and vote on what are the additional benefits that are most important in their sector. Workers who are doing domestic work, for example, might have different needs than workers who are driving taxis. And third, protection of the funds. I mean, we have the federal ERISA law for a reason, and if we are assuming that workers are not employees for the purposes of ERISA, we have to find a way to make sure that the funds that are being paid are protected. Finally, I just want to mention there are some very thorny legal issues to look at when we think about portable benefits. One is this issue of ERISA. But if workers are independent contractors, there are also issues, for example, such as antitrust. If workers want to come together to negotiate for wages, they are that implicates antitrust laws as well. And I think that one adjunct to a portable benefits proposal would have to be setting a wage floor. We think that the best opportunity to really think about portable benefits is to think about workers in a sector where there is a core of full-time, long-term workers rather than workers who are in and out and in a couple of weeks, which is often the case for workers who are doing on-demand work. Taxi might be an example, home care, child care. And we think there's a very good example with the New York Taxi Workers Alliance and the Health and Welfare Fund that they've been working on. Now, taxi workers are considered independent contractors. The Taxi Workers Alliance has identified specific needs that could be paid for through a portable benefits system. So we're excited about thinking about portable benefits, but we think there are at least 2 steps and a lot of issues that need to be resolved before we are ready to establish portable benefits for workers in a variety of different occupations. And with that, I'll turn it over back to Kim and then on to Larry. Thank you.
Absolutely. Thank you. I'm glad folks are asking their questions. We are arranging them right now so that we can make sure we try to get to as many as possible. But before we go into our Q&A, next to close this out, we have Larry Engelstein, who's from SEIU 32BJ, and he is going to give us some ideas about an important fight that is taking place right now in New York State and how this has national implications. We're really happy to have him here to give us an update from the front lines and hopefully also answer some of the questions around opportunities for organizing. And Larry is the Executive Vice President of SEI 32BJ and Director of Collective Bargaining and Employer Relations. Just for folks, some background, SEIU 32BJ members work primarily as cleaners, property maintenance workers, doormen, security officers, window cleaners, building engineers, and school and food service workers. Larry comes to 32BJ with 20 years of experience as a labor lawyer and community organizer, including experience with the AFL-CIO. Larry, we're so proud to have you here, and if you want, just go ahead and take it away.
Thank you. Our local union, as has been described, fundamentally operates within the structure of the fissured economy and has for decades been a voice for bringing workers together and supporting workers' efforts to find stability, dignity, control, and improved standard of life, notwithstanding the fact that the nature of the way in which employers and end users have sought to structure the work has evolved and changed over those decades. So I guess I will focus first and quickly on some legislation that has been proposed by platform company advocates in New York State. And given where New York State sits within the political architecture of the United States, if these kinds of legislative ventures are to be successful here, it suggests that they will have the potential for uptake across the country and also possibly federally under the new administration. So they represent a significant challenge to those of us who are seeking to continue to protect the rights of workers to act collectively, notwithstanding the fashions of the day. So what has been proposed in New York State is a form of legislation that would essentially provide for what are called the workers who are providing the actual service that's facilitated by the platform intermediary to have a certain amount of money diverted or included within the fee that is charged to the consumer, the end user, the person who's the recipient of their services, that would be then go into a fund that would be independently administered. The concept is that a variety of platforms, if a worker was to drive for Uber one day and to perform a service for Handy the next or Instacart the third, each of them could be having a piece of the fee diverted into this fund, and that fund then would be a vehicle for purchasing a array of benefits that are itemized in the proposed legislation, which are health and retirement type, for the benefit of the worker. I'm calling the person a worker. They have a different term because the point of the law, and the concept then is that these benefits would be portable in the sense that the different platforms that are providing the work for the worker all would be putting into a common fund, and that fund would stay with the worker as an individual account, and then the worker would be able to theoretically amass sufficient benefits through that or sufficient money through that process to be able to purchase something of value for themselves: eyeglasses, dental care, whatever. So the other parts of the bill and the fee the amount that's indicated at least as been floated is on the order of 2.5% of, let's call it, the wage for this purpose, or the fee of the price of the service. So the other components of the proposed legislation, which are in my mind quite invidious, is in order for this to happen, the platform or the intermediary enterprise is essentially immunized under state law from any claims that it has misclassified these folks by treating them as independent contractors. That proposed immunization, or safe harbor, as they would call it, runs not only prospectively from the time of the legislation, but actually retroactively, which I'm not smart enough to know the legal propriety of that. So essentially the scheme is, here, I'm a platform company. These folks are independent contractors. I would like to be able, so it goes, to be able to provide them with the level of some level of benefits. But if I do that, then I may provide greater evidence to those who are claiming that I should be characterizing these folks as workers. So in order to allow me to continue to classify them as independent contractors, but also to give them the kind of benefits and other support that I would normally give a worker, I want to have a state law that allows me to be immunized from any legal consequences from this manner of provision of benefits. So that's the fundamental scheme, and our local, along with others in the labor movement and the Taxi Workers Alliance, has been opposing this, and for multiple reasons. I'd say, first off, if the actual motivation for this is to provide an adequate benefit regime, it's a bad deal. The statutory load, as I think Becky has suggested now, for somebody who's classified a worker is in excess of 10%, and that's not even talking about the provision of health care or anything that's not mandated by law. So this is a pretty bad deal, just on its own terms. Secondly, I don't think it's at all clear that there's anything given, particularly as David has described, that says that because of the technological intermediation in the arrangement or connection of the worker to the client, that suggests that the traditional common law analysis of whether these folks should be treated as employees or independent contractors has to come out that they should be independent contractors. So it's our sense that there's a substantial, for a huge range of these folks who would be the beneficiaries of this legislation, I mean the intermediary, the platforms, that this would allow them essentially to get away, to sanctify their form of misclassification. And that is a very slippery slope and will spread to other forms and encourage and undermine the existing structure of work that we in our local and others in the labor movement and workers generally have fought for decades to ensure is not eroded. So it seems like it's not warranted by the structure of the way the work is now set up. The deal itself that's being offered is not sufficiently, it doesn't seem to me, if you were just to look at it as a deal, not worthy If they were willing to offer, 20% and 25%, well, who knows? You might consider that a different moment, but that's obviously not the case here because it would undermine the very motivation for constructing these jobs as independent contractors rather than treating them as employees. So at a minimum, you would say, am I going on too long? I'm sorry.
No, next slide, maybe?
Oh, okay, slides, yeah. So that's, and I guess I'd want to make one kind of final point before we get to the questions, which is the way in which work is structured, whether there is an internal labor market created, whether vertical integration or horizontal integration is in fashion in a given moment or within a given industrial sector, is not preordained. It's not that technology is necessarily defines the way in which the power relations in a arrangement providing labor or services ends up. Part of how that ends up being constructed is a matter of what the workers themselves want and the kind of struggle in which they engage in to reshape what is initially presented them as a set of arrangements which is dictated by technology, by God, or by whatever is the current dominant ideology that is trying to preclude workers from having control over their lives and their own workplaces. And so I think it's very important to not assume that there's something inherent in the fact that work is part-time or that there is an intermediary technology present at a given moment that suggests the outcome of how the work should be fundamentally structured at the end of the day. And there is a certain aspect to the current efficacy for these platforms that has a kind of right-left combination in which there are those who are saying that the New Deal is dead, that the provision of social benefits and the structures that existed for workers to move forward are outdated and no longer meet the current needs of the economy. And they provide, I think, a certain cover for what is a much colder calculation, which is how to minimize the cost of labor for these new forms of operation. And it's important, and I think David's slides that indicate the very small percentage of work that this new mode of organization currently consists in the economy, it's important not to allow that to drive a rhetoric which displaces the accomplishments, however limited, however complex, however compromised they may have been, of what workers in the labor movement and working people have struggled for over the last 70 years. If these kinds of laws are passed, what happens is you have an individual contract with the Uber driver, for example, or a worker or a provider of services, which will have a clause that sends everything to arbitration, deprives them of any statutory remedies they might have or any contractual disputes they might have, because of antitrust laws, would preclude them from acting collectively to approve the terms and conditions of the contracts of adhesion that they are presented with in terms of the rates they have to they earn, their commissions, the hours of work, the way they have to make themselves available. And all that, and losing the entire fabric of statutory protections that have been enacted for workers. So seems to us not the right way to go. And, in our local, there are 100,000 workers and more who have portable benefits through collective bargaining, Taft-Hartley benefit plans that when one contractor replaces another at their work site, both contractors contribute to the benefit fund and the workers' benefits continue without interruption. It may not be the best model for everywhere, but the idea that portability can only be achieved through making a deal to allow workers to be classified or misclassified seems to us not one worth taking at this time. Thanks.
Thanks, Larry. We just heard a lot of information, and especially happy to have a lot of questions from folks. And for the sake of time, I want to make sure that we get to the broader stroke questions as possible, and we'll make time for some of the more specific ones. So first, we're going to make sure the screen that you're seeing right now are the resources that NELP has had that is created over the past couple of years around the gig economy. And we'll send out this presentation within the next couple days so that folks can click on those links and see them up in their website themselves. We'll also like to make sure that you all have results from our poll. So if we can get that slide up. Great. So we heard from you all, and I appreciate you all taking the time to answer the poll. What else would you like to learn about the fissured workplace? Majority of you said state and federal policy solutions.
Hi, coming in.
And then the next highest is worker organizing strategies, and then portable benefits, litigation, and agency action were the last two. So can we go to the next one? And here, this is where you all are coming from. Your work, majority of you actually said others, so I'm really intrigued to hear maybe the folks in business or academic institutions. But we have government, folks who are lawyers, work in unions, and worker center. So thank you so much for taking the time to answer the polls. I'd like to get started with some of the questions that we asked Dr. Weil, and first I'm going to see if he's still on. Can you unmute him? We'd like to hear more about in the branded on-demand model. Do general agency principles as outlined in Darden apply in determining whether someone is an employee of the branded app?
Yeah, I mean, can you all hear me?
Yeah.
Yeah, thank you.
Okay. So, I will go back to what I said before about the criteria one needs to use in order to think about whether or not someone is an employee or not. And it really comes back to the same fundamental principles. These are principles. We understand it's complex. I'm still saying we as if I'm still at the wage and hour division. Old habits die hard. But, the understanding that this is not a simple matter, it never has been, is why we, in 2015 at the Wage and Hour Division, issued something called Administrator Interpretation, which was a statement about who, given the state of law, regulation, and decisions by courts, is an employee and who is an independent contractor. And those are the set of factors that have, it depends which statute we're looking at. Under the Fair Labor Standards Act, we have one of the most broadest statements of what it means to employ someone. To suffer or permit work is the phrase used in the Fair Labor Standards Act. There are other common law principles that are applied to other statutes in making that determination. But these are things that I go back to the basic notion that it's not specific to the digital, the on-demand world, and thinking about basically how much does that party have to do things, a party who we're deciding whether they really are a legitimate independent contractor, how much ability do they have through their own actions to make a profit or not? How much latitude do they have to determine the conditions of business? How much capital and skill are they bringing to bear on that? How much managerial authority do they exercise in undertaking their work? These are basic factors that really are not about whether or not someone's working on the on-demand in the on-demand economy or not. They're more fundamental to just what's the underlying nature of work. And I would conclude that by saying, I have had many discussions with people in this sector representing all sides of this issue, where people say, yeah, but isn't the digital economy, isn't the on-demand sector particularly complicated and messy in this regard? And I would cite a case where the Supreme Court weighed in on this. And in the decision of the Supreme Court said the borderland between what is clearly an employer-employee relationship and what is clearly one of independent entrepreneurial dealing is gray. That was the Supreme Court decision in NLRB versus Hertz Publications involving newsies. We're the newsies, the kids who actually distributed Hearst's paper, independent contractors or employees in terms of the National Labor Relations Act. And that was a decision handed down in 1944. Now, I don't want to say the world isn't changed and nothing's new. Obviously, a lot of things are new. But the principles of who we try to protect with our basic labor standards and all of our job safety net legislation really are quite useful, have struggled with grayness between making that designation for decades and decades. And I think that really brings us back to the moment at hand. Many of the things that Larry talked about in the end, I think, are, again, the kinds of considerations we have to be very wary of taking in deciding whether we really need new principles or whether we just have to be careful about applying the existing ones to these new arrangements.
Thank you, David. I also think, as far as the comments around independent contractors, Larry raised a really good point that technology does not define power relations, and I think that's a real good takeaway that you just reinforced. I want to go next to the question about policy responses, and I have a question. It's a little long, so bear with me. With fissured employment, it often seems like the worker is clearly an employee of someone, just not always considered an employee of that primary corporate overseer. Aren't the issues or policy responses different here? Proper classification of misclassified employees versus application of the joint employment doctrine of fissured arrangements? Rebecca, do you want to take this one?
I will, but I'll probably move it back to David, who has written administrative interpretations on both of these issues. They are two separate questions, and we sort of think of them as, part one is the worker an employee of someone, and part two, as in the hotel case that David talked about, and many others, are there more than one employer? And the Fair Labor Standards Act and other statutes address joint employment. David, do you want to say more about that?
No, I think, Becky, I totally agree. I think, the point of the fissured workplace and the changes that have happened is there's just more and more complexity in those employment relationships. And exactly as Becky said, you have to do very often both kinds of analyses. Is the person an employee in the first place? And if the answer to that is yes, then who are the party or parties who are ultimately responsible for the conditions of work? And clarifying both of those things is something we very commonly find under the Fair Labor Standards Act and many statutes. And again, I would say those things are going to crop up in the on-demand economy just as they do in the brick and mortar world.
This is Larry. Can you hear me?
Yes.
Yes.
Yep.
Thank you.
Yeah. I mean, the whole question of joint employment under the National Labor Relations Act is an incredibly important one and been, to some extent, a subject of recent case law and controversy. And will continue to be, I expect, when the Trump board fully is populated. But at the end of the day, I think we should all start with the proposition we shouldn't see the terrain that the worker is an employee of somebody. Whether the components of the key decision-making over the worker's life are shared or split between a building owner that controls the right of access to the work site because the contractor is working on not on its own premises but on the building owner's premises, whereas the contractor is conducting the hiring without regard to the landlord's preferences, but the landlord's setting the hours of employment because the landlord is saying what times of day that the contractor can be present in the building for the workers to work, etc. How that's allocated, who's going to end up with a legal responsibility for the secondary boycott provisions, purposes of the Labor Relations Act for petitioning whose name is on the certification that would issue Those are all important issues, but we lose all that if the baseline proposition is somehow or other through misclassification, these workers fall out of that entire discussion. And so I think that is sort of the common ground that we all have to keep our eyes on as we wander through the niceties of trying to determine co-employer or joint employer responsibility and what those respective obligations would be between the other entities or the multiple entities that may affect the life of the employee.
Thanks, Larry. I have a follow-up question for you. And this is a bigger picture, and then after that I'm going to ask a very specific one that can be quickly answered. But we have a question here from one of our participants. How do you address the push to classify most workers as independent contractors and the fact that these groups have more limited options for organizing?
How do we address that?
Yeah. How do you address
we used to have an ally in David in the federal government. That was important. I think the issue has to be addressed through struggle, and that takes a variety of forms. It takes the form of engaging agencies to enforce the law and not allow there to be misclassification, and it takes the workers themselves to engage. If folks are truly independent, contractors, then there's a different set of issues, and presumably they're going into that line of business understanding that they have risk and that they have opportunity for gain and profit. But I think it's going to be a function of conflict and struggle.
Yes, it will. Okay. A very specific question related to the New York bill that you were talking about. Does the Senate pass version of the New York bill include the proposal, and what are prospects in this assembly?
Yeah, I'm not competent to be a political prognosticator. We're hoping that the bill doesn't pass.
All right. Thank you. So it's 5 after 3, and we appreciate folks still hanging on. We're going to try to take a couple more questions, and we have until about 3:15. So if you're not able to stay on, please know that we will be sending out a recording, and so you won't have to miss this end question and answer. Okay, so we're going to ask another question. There's one that was asked about basically the race to the bottom. Is there a way to do portable benefits that does not result in a race to the bottom? Rebecca?
I still think – oh, go ahead.
No, go ahead, please.
I still think we're figuring that out, but I think that one component of doing or two actually components of doing portable benefits that does not result in a race to the bottom is to ensure that folks are covered by social insurance. And one of the reasons for that is that many people who are working in on-demand are not there forever. They are holding two different jobs. One might be more traditional. And so you want contributions to their workers' comp fund to happen for both of those jobs and cover both of those jobs. And the other is that people are in and out a lot. So if you have some kind of privatized workers' compensation fund, they're not going to really get the benefit of workers' compensation. And I think the second is, as you think about portable benefits, I think the initial forays have to be in sectors where folks really are pretty clearly independent contractors. And there are a number of those sectors, but again, the sector and the project that we think is most promising is the one that was undertaken by the New York Taxi Workers Alliance. I'd say maybe a third thing is that you need to set the portable benefits contribution at a level that does not encourage misclassification. So you can't be offering 2.5%, as does the bill that has been circulated in New York, as an exchange for the 17 to 21% that an employer would pay into mandated benefits, if you include health care, certainly.
Yeah, I was going to just emphasize what Becky said at the end. The way you avoid the race to the bottom is, first of all, you don't start the discussion by saying, what basic fundamental rights do we trade away to get portability? I think, one of the things that it has truly changed in lots of parts of our economy, not just on demand, but in lots of parts of the economy, is the reality that working people's lives, really at lots of skill levels, is going to be more volatile. That's the nature. There are a lot of forces that are pushing in that direction, which says we do have to think creatively going forward about different ways of providing portability of things like pensions, training opportunities, something that I don't think gets enough attention. The Affordable Care Act provided greater portability. We don't know what lies ahead in terms of what Congress is going to do with that. But the need to address that, I think, is fundamental, and we have to think about some of the considerations that Becky and Larry have raised. But you don't start the discussion by saying somehow we trade these other fundamental ways of not shifting risk back onto the worker, which has been happening too much over the last decades, and conduct the discussion about portability really as a separate kind of matter from the protections of basic workplace rights and standards.
And this is Larry. I mean, one other observation is the level of immiseration that is a function of low wages and expanding inequality is often, to me, lost sight of in this discussion about portability. There's another conversation that's going on, which is workers aren't saving enough. Nobody has private pensions anymore. Let's create a law that nudges workers towards saving by creating portable 401ks that deduct from workers' pay a certain amount of money so that they will have money apart from Social Security when they retire. Now, we're talking about, tens of millions of people in this country who make less than $15 an hour, and, talking about constructing a supplemental form of a retirement scheme based upon a foundation which is inadequate income. So, I think it's appropriate to acknowledge as a policy matter the decline of private pensions as a supplement to Social Security. But to suggest that you can have a solution to retirement security where people are living a life of income insecurity before they get to the idea of retirement seems to me kind of out of whack. And so it's without a holistic approach to dealing with the reality of the current nature of employment, both its greater volatility and what's happened in terms of the relative income power, it seems to me that the policy directions we may get lost.
Thank you. I have one more question to ask for David Weil, and then we're going to close this out. And this final question is going back to your presentation. When this participant asked, have any researchers been able to find out the standard percentage or finder's fee for the branded or unbranded task platforms?
Oh, that's a great question, and I don't know of any such study. I think it would be a fascinating thing to look at that. But I don't know offhand the answer to that question. I will say, and I think Becky mentioned this in passing, and I think it's something that really bears greater attention, and that is there are a number of these on-demand platforms that have either begun with an employment relationship as the basic premise of how they organize themselves, or have moved towards that. A number of these have been, for instance, recently in the home healthcare space. And I think it's interesting to look at those models, and I think it gives us something important to understand about really, in a sense, the argument that needs to be made back often to businesses in this area, and that is often businesses act, and I've heard this argument many times, sometimes posed in the form of, we need a sandbox in the digital space to play in because things are emerging and these darn laws that make us have to decide independent contractor or employment are just too hard, and it's undermining our ability to innovate and try new things. And I think it's when you think it through, it's just a nonsense argument in that in any area in our economy and in businesses, businesses should start with understanding what they're trying to do in terms of their strategy, in terms of the way they're trying to reward their investors and serve their customers within the context of laws, within the context of the protections that that we have stated in our different federal, state, and local standards, and then work from that. There's nowhere where we sort of say, figure out what you want to do, and then we'll kind of push back the laws to accommodate that. And I don't see a compelling need to do so in this realm any more than others. And I think the best demonstration that can go on is the fact that you see more and more companies who are figuring out they need an employment force that they can put investments in and train and have low turnover with to make their branded platforms work. And when you start saying, if that's what I need, then what have I created? I've created an employment relationship. And so a responsible employer is going to then go forward with that rather than continuing to fight this war about, let me call them independent contractors because the digital economy is somehow different. And I think, underlying this question about the premium for pay on those platforms is this more fundamental question about business models and what businesses are trying to do in this space and what we as society should require them as sort of the basic social contract we have that's embodied in our labor laws and our workplace laws if you're going to play in that space as you would have to in doing business in any of the economy.
All right, thank you. I just want to open up for any last thoughts that you want to put out before we close, Larry or Rebecca?
No, thanks for everyone who participated both as listeners and as speakers and as questioners and moderators. That's all.
Thank you so much.